Hi, everyone. My name is Brenda Lopez. I am a certified family law specialist. I have a founding partner of my own firm, Patterson Lopez Banuelos Kitterman, and I am going to be going through this webinar today for the San Diego Volunteer Lawyer Program on evidence and how it plays into a request for a domestic violence restraining order. So let's jump in. I'm sharing my screen, so hopefully this works out. Lawyers and technology don't always work, but let's give this a shot. So the steps. Let's talk about the steps. So first, you need to identify relevant evidence to the request for a restraining order to show the abusive conduct. So identify what evidence you have. And then you have to prepare the evidence for your court hearing. You have to file the evidence at the courthouse before the hearing. You have to serve that evidence on the other party against who you're filing this restraining order prior to the hearing. And then you have to use the evidence at the hearing on the restraining order request to support what your side of the story is. Why is it that you need a permanent restraining order? So the purpose of the evidence, let's talk about why it matters. As the person that filed a temporary restraining order and asked for protection, you're the one that has the burden of proof to show to the court that you need a permanent restraining order. The standard. So there's always a standard for the proof that you need to support. And in a request for a restraining order in family court, the standard or the burden of proof is a preponderance of the evidence. So what does that mean? For us lay people who maybe don't have a law degree, preponderance of evidence pretty much just means that you have to show evidence to show that what you're saying and the reason for what you're requesting, it's more likely than not. So we put in here 51 out of 49% is more likely than not that conduct occurred and the basis for why you're asking for the restraining order and why it should be granted. The evidence is used to support your testimony regarding what happened and to support your request for the order. So types of evidence. What is evidence? Evidence could be testimony, and that could be in declarations that you're submitting to support your request for the restraining order. It could later be, if this turns into what's called an evidentiary hearing, it could be the testimony live in court. So that's one type of evidence, is a testimony, whether that's just of you asking for the restraining order, or if it's in addition to your testimony, other third parties that might have witnessed the abusive conduct. The other is photos, so photographs of the injuries that you sustained, the property that was destroyed, the witness statements. So these are the third parties. Then police reports. If there was a police involved in the incident or incidents, then there is a police report. So that's another type of evidence. And just so you know, you as a victim of abusive conduct are entitled to a free copy of that police report. Other orders. So if there's if this is a military party on the other side and there's a military protective order, if the police were involved and now through that means there's also a criminal action and there's a criminal protective order. If the police were involved and the police issued an emergency protective order, so that's another type of evidence to submit. Other things are medical records of the injuries that you sustained. I will advise you here, I won't dive too deep into this, but when you submit medical records, it does open the door, in my opinion, to break the physician-patient privilege as to those issues, those medical issues. So the other side could ask for additional documents related to those medical treatment that you are submitting maybe partial evidence of. So just keep that in mind. Other records are child welfare services. So sometimes when there's children involved, especially if police get called in if they think that it rises to the level of abusive conduct. The police, like doctors and therapists and teachers, are mandated reporters. So sometimes they report automatically if they think it rises to that level to Child Welfare Services, and then that'll prompt an investigation perhaps, and someone appointed to the case. If there is someone appointed to the case on Child Welfare Services to investigate, sometimes as part of the investigation, they issue what's called a safety plan. And that's a plan that then you would submit to this court for family court as further evidence for why the protection should include children, and what their Child Welfare Services recommendation is. Other types of evidence are copies of text messages or phone call logs if you're saying that the party is just calling incessantly, or the text messages that shows the abusive behavior. Make sure that when you do that the call log has the identifying phone numbers and dates, and then also, and I would highlight that information that you're pointing the court to, because the call log is going to have a lot of other phone numbers and things that the court doesn't really need to look at. Then in terms of the text messages, I would make sure also that you have the name and the phone number. Sometimes people put the other party as a derogatory name as on your phone, so that you know who that is and maybe not to answer. I would make sure that you don't submit that to the court. You submit it with the full name and the phone number showing as well. Other types of evidence are audio or video recordings. I will tell you that you should keep in mind that there is a penal code section that prohibits someone from video recording. It's actually a misdemeanor to record someone. It's an invasion of privacy, except in certain situations. So perhaps talk to an attorney before you submit a video. Some basic overview is if it's in a public area, a park, I don't know, something that's out in the public. I don't necessarily think that would be under the protection. And some other scenarios are if it's of certain criminal conduct or abusive conduct. In certain scenarios, it's also allowed. But again, I would definitely talk to someone before you submit an audio or a video recording. Obviously, if you've already filed the restraining order and the temporary was granted and it allows for you to video record, that's also an exception. So some general rules. Any evidence that you want the judge to see must be filed with the court and served on the other party who you're filing the restraining order against at least 5 days before your hearing. I would say look at the restraining order, the temporary restraining order, and usually somewhere on there it says you have to serve this by X. It's usually 5 days, but I would just make sure you look at the order, because whatever says on the order, go with that date. And that's for not only serving the restraining order, but any evidence that you want to be considered, I would do it by that date too. Evidence should be relevant. So it has to be actually relevant, and it has to directly support the statements that you're making in your declaration. So organize your evidence so you can identify which incident it corresponds to. Testimony. So let's go through all these. Testimony. The judge will have already read your declaration. You can even ask the judge if you wanted to just confirm at the hearing date that he has or she has reviewed your declaration, but it's assumed that the judge has read your declaration. The judge will ask you at the hearing if there's any additional or new information or anything that maybe is in there that needs to be modified or changed. So I would mention things like things that are important are changes to your declaration, because you got to remember that you are filing these declarations under penalty of perjury. That's huge. You are saying that you're saying the truth. And if the court feels you're being dishonest, it's going to play into the request for the restraining order. So minor changes, I would say, okay. Major changes, it will affect your credibility, but I also think that you have to be honest with the court. So that's one thing that you need to point out, is if anything was inaccurate in what you've submitted already. And then the other thing is anything new that's happened since you filed your paperwork that the court should know, which are things like new incidents of abuse, violations of the restraining order, things that you forgot to put into your declaration. These are the important things that you would mention at the hearing. Don't repeat necessarily everything that's in your declaration, because again, the judges have most likely already read it. Then the judges can grant the order based on only testimony with any additional evidence. So you should know that the court, in some cases, there is no additional evidence other than your testimony. Sometimes you just don't have a video, you don't have a photograph, you don't have, it's not the phone call situation, it's not in text message, because everything happened either in person or on the phone. So sometimes there's just no other evidence other than your testimony, and know that that is okay. The court can still grant the restraining order based on just testimony, which is another reason why it's so important for you to be honest and for the court to think that you are credible. And then remember that you have a right against self-incrimination. It's a Fifth Amendment right. You can say that you don't want to say anything about a certain topic because it could potentially incriminate you, and the court can't use that against you. You have that absolute right. So keep that in mind. So photographs, let's go to photographs. These would be photographs of injuries. Best if the photograph identifies you, like you can actually see your face, or it's at least has a date, is important to have also, is when was this photograph taken. You can also send photographs of any of the property that was damaged. So this would be a broken cell phone, a vandalized car, holes in the wall, holes in the door, shattered windows. You get the idea. So the destruction of property, those photographs are important to submit if you have them. Surveillance photos, again, back to the recordings, just make sure that the surveillance photographs that you have wouldn't be an invasion of privacy situation where you could then be facing a misdemeanor. So, but you can use surveillance photos, just keep that in mind. Best to have a photo, again, that's time-stamped or date-stamped. And then make sure to explain what the photo shows, who took the photo, why you're submitting it, that you didn't alter the photo, and you put that in the declaration when you're saying attached is a photograph, and you explain what the photograph is showing. Also, photographs of any proof of violations of the restraining order can also be submitted. Witness statements. If someone has witnessed the abusive conduct that you're alleging, then you can provide a statement from that witness attesting to what they personally either heard or saw. They have to have witnessed it. So remember not to use statements from witnesses that you regurgitated a statement or an incident to, right? So you telling your friend this happened or anything like that, they have to have personally witnessed this in order to testify about it. And if you do have those witnesses, then you would use the form. If you Google this, you'll find it online. Google MC030. And then if you need more room, you can use MC020. Those are the forms, the Judicial Council court forms that you can use for these declarations from the third-party witnesses. I would, in addition to what I'll go over right now, I would just take a break here to insert some information or some commentary from me on witness statements. Do not tell the witness what to say. Ask the witness to simply tell the truth and to write down what they observed. So that's big. You don't want to tell them what to say. You want to let them tell their story, and hopefully, and if you're going to submit it, it should corroborate with your version of the events. If it doesn't, you might want to consider whether or not to actually submit that statement. The witness should identify, again, who are they, maybe how they know you, and any detail, again, of what they witnessed and when they witnessed it. They should be available to attend the hearing on the restraining order. Some judges will require the witness to be at the hearing in order to consider their written declaration. So I would just have them handy. These days, makes it a lot easier that the court in San Diego County is still optional virtual or in person. So it makes it a little easier for these witnesses to simply log in online or when they need to be, right? And they could just go on with their day and then take a break to appear if they need to. So it's a lot easier that way. They don't have to literally spend a whole day in the courthouse or half a day in the courthouse just waiting to see. Now the virtual option makes this a lot easier, but that witness should be available for you. Oh, sorry. Then they should be, again, minor children. If there's any minor children, generally cannot be witnesses. But I would say that minor children that witnessed abusive conduct, they could be used depending on the age. But I think that I would have minor children outside of the courthouse, or if I'm going to be using them as a witness and this needs to be an evidentiary hearing, point that out to the court so that the court can kind of guide you on how it wants to hear from the children. They're in a position where they have to safeguard these children, and they can make decisions on how they're going to hear the testimony, if they're going to hear it at all. So keep that in mind. Sample witness statements. So here's a sample that you could use. So again, witness name and how they know you. My name is Anna Fake, and I have known petitioner Susie Sample and lived with her as a roommate for the past 3 years. Then general information. I have witnessed her boyfriend, Henry Jones, being verbally and physically abusive to her. When and where? Give me some detail. For example, on June 1st, 22, I saw him grab her by the hair and push her against the wall in the living room of our apartment. While calling her a fucking bitch, she screamed and told him to leave her alone and that I was calling the police. Then he left. That's the detail of what happened. When, where, what happened. And that should be for any incidents that they're witnessing to. Profanity. So I, for one, do include in quotes the statements that are being made, and I spell it out. If they're using derogatory words, I spell it out what derogatory statements they said. The judges need to see that, need to know that. That's the abusive conduct. So I don't sugarcoat it. I actually do spell it out. It's not your statement, it's a statement from the other side and why you need the restraining order. So I definitely include the statements. Again, just remember to put them in quotes and say that that is what is being said by that party. Police reports. If the police came out when the incident happened, they likely gave you an incident number or a case number. Make sure you keep that handy because, like I said, you'll need that in order to get a copy of that report from the police station later. And you'll also want to provide it in your statement to the court. You should also, again, go to the police station and get a copy of that police report. Keep in mind that that could take several weeks. So you might not have it at the moment you ask for the restraining order. So your declaration can simply reference this agency showed up and here's the incident or case number. And then if you have sufficient time, if the report comes out and you have time to submit the report later, I would do that. You should try again to get that report. The police reports can be picked up from the police station that responded to the incident. So reference the chart in the closing packet. Read the police report before you turn it in. And this is an important thing no matter what it is. If it's a police report, if it's a witness statement, if it's a declaration, if it's a video, if it's a text messages, if it's a child welfare services packet, you want to read everything before you submit it to the court, submit it to the other side. You want to make sure that it's, one, not going to go against what you're saying or going to be hurting your case, but two, you want to make sure that it's accurate as well, and that there's no mistakes in it before you submit it to everybody. I went over at the beginning the types of orders that you can submit as evidence, and here I'll explain it a little bit more. So these are the acronyms that we all know, the court's going to be familiar with, the attorneys are familiar with, and you should be familiar with. So MPO, that is a military protective order. And again, this comes up if there is a military member on this case on the other side. Another thing is a criminal protective order. We call it a CPO. This is if there was an incident, the police come out, the other party was arrested, there's an open criminal case against them, and that criminal court issued that criminal protective order. Another type of order is an emergency protective order. We call it an EPO. These are restraining order types. They're very short, and it's issued by the police. If they come out to an incident and they think that that's necessary, they communicate with a judge, they get a protective order, and it's very short in time because it's only supposed to protect that party between now and when they can get into court to ask for a civil or family restraining order. Again, provide these, if there are any of these in your case, provide copies of this to the court. Other types of evidence is medical documents or records. If you went to the hospital and you received treatment because of the abusive conduct that occurred, provide a copy of those records and any instructions that you may have. Remember that the other party will need to receive a copy of them to confirm that there isn't anything on there you don't want them to know. And if necessary, you can redact the information with black permanent marker or whiteout. Again, I mentioned it at the beginning, just keep in mind that if you submit these medical records, in my opinion, you're opening the door for them to get additional medical records as to those injuries and dates of service that you are saying in your declaration and that you're providing as evidence. So maybe you only provided a part of it. They can go ask, in my opinion, for all of the records relating to that date of visit that you're submitting partial documents for, and for treatment for the injury that you are alleging. If you didn't submit all of it, that there might be a reason, and in my opinion, they could get those records. Which would otherwise, medical records are typically privileged, and you cannot request that information, is a general rule. Obviously, there's some exceptions to that. Copies of text messages and call logs. So we talked about this earlier. Take screenshots of text messages or the call logs that show the verbal abuse, the threats, or the repeated contact. Make sure that the date of the messages or the phone calls is visible, as well as some way to identify who sent the text or who's making the phone calls. Don't try to mislead the court by only providing one side of the conversation, because the other side will have an opportunity to provide the complete conversation. And so don't just put one side, because the other side can always put the complete story, and you don't want the court to think that you misled it by not providing the complete message that would have otherwise been a different story. Messages in a different language. So if you have the text messages and they're not in English, the court requires you to provide an English version too. It actually has to be translated by a certified translator. And you can find people, you could probably Google search certified translator in what language you're looking for, and they'll charge you, but they'll translate it, and then they'll give you a certification. So they'll give you the English version, and they'll sign at the end that they're testing that is a certified translation of that message. So keep that in mind, that is a requirement. If you don't do that, it doesn't matter that the judge speaks the language of which you did not translate the message of. It does not matter. The court has to have a certified translation, and that could be crucial in your case to have. So just make sure that you do that ahead of time, and then you serve that with your packet that I'm telling you, look at the order to see the deadline, but it's usually 5 days before the hearing. Audio or video recordings. Copies of recordings I would put on a thumb drive or a DVD, but I typically do it on a thumb drive. I do put it in an envelope with the case number, the name. I even reference on the envelope the exhibit. number or letter that I'm submitting it for. It has to have a written transcript of the recording. That could be, that's not necessarily certified translator. This is in the sense of not translating a document, it is transcribing a document. So don't get those two confused. Transcribing is when there's an audio or a video clip and you have to have the written version of what is said on that audio or video. I include that as an exhibit. That is usually the exhibit that follows my audio or video, and I submit that as well. The court will most likely not review that audio or video at all before the hearing. At the hearing, it will ask you to play it on a device, and that could be your laptop, or some other way to play it for the court. There's certain rules for the court, so they typically won't play it on their computers or anything like that for reasons that, I mean, I won't get into too much of the complications, but they will ask you to play it. So just make sure that you're ready and have a way to play that audio or video recording in the courthouse on the date of your hearing. And you do have to give the transcript and the audio or video to the other side, along with everything else that you're submitting. So how now you've gathered your documents and your evidence and your videos and everything that you need, you've gathered it all together, now what? So all the evidence that you are going to submit to this court must be filed at the courthouse at least 5 days before your hearing. Again, look at the order for the restraining order, because it might have a different date. If it has a different date, go with what is on the temporary restraining order. When you submit the evidence, you are going to make 3 copies of everything and then take it to the court for filing. 1 copy will stay with the court and the court will give you back 2 copies. You will keep 1 and then you'll serve the other party with 1. So you have to do a lodgement for anything that's over, I believe it's 10 pages as an exhibit. If you have exhibits that are more than 10 pages in total, you'll have to use a notice of lodgement. And so if you Google the Judicial Council form, you'll find a notice of intent to lodge documents. So look for that online, and that's what I would recommend be used as the notice of lodgement that has to accompany the evidence. And you're labeling each piece of evidence as its own exhibit, each photo as its own exhibit, each text as each text chain. So there might be multiple pages of a text conversation, but each text chain as its own exhibit, each audio or video as its own exhibit, orders as its own exhibit, and they're chronological. So for example, exhibit 1, 2, 3, 4. Identify each exhibit. So on the notice of lodgement, it'll say, okay, what exhibit, letter or number, what is it, how many pages, and then you sign it. So it makes it user friendly to use that form. Again, it's a notice of intent to lodge documents. And then on the actual exhibit itself, label it, exhibit 1, exhibit 2, exhibit 3. Here is that notice of intent to lodge document that I was referring you to. So this is a sample of it. If you see on the top, you're going to put your information, right? Your name, your address. Then you'll mark in the box here underneath where it says Superior Court of California, you'll mark the box for the court that this is in. The petitioner would be you, the respondent's the person you're asking for the restraining order against. They gave you a case number, or they will give you a case number if you don't have it at the point that you're filing this, because you're filing it with your request. Leave that blank. The date, time, and department, if this is the first document with your restraining order and there is none of that yet set, leave that blank. If you have that information because you're submitting this after you've filed the request for the restraining order, then put that information in it. Then you'll see Susie Sample hereby gives notice. So you'll put your name, whoever is in lodging, that's the name that will go where it says Susie Sample. And then you'll see exhibit number, description, and page numbers. So this is where you'll fill that information in. Procedure for serving the evidence. So the other party has a right to see all of the evidence that you want the judge to see. Once you file your stuff at the business office, you'll then serve a copy on the other party. A third party must serve the other party by either mailing it to them or physically handing it to them. Then after the service is complete, there is a proof of service form that must be completed and filed with the court so that the court knows that it has been served. In certain situations, the police has to actually serve the restraining order. And this is when there is what I call a kick-out order. So it's an order for removal. These are in situations when you live with the other party and you get a restraining order and you requested a removal order to get them out of the home or apartment. And the court grants it, then the police has to actually be the party to serve the restraining order and to remove that individual from the home. So in that situation, you have to have the police do it. In others, it doesn't have to be the police, but the police provides this service, I believe, free of charge, and is typically what I use for it, unless there is a party that is going to be really hard to find or serve, then I might hire a process server to personally serve that party if I want it done immediately, or if I have to, it has to be on a certain date, certain time, because when you give it to the police, there's no knowing when they'll be able to do it. They do it whenever they have the window of opportunity in their busy day. So if you want it done on a specific date, specific time, I'd hire a process server if it does not contain a kick out order. Because again, if it does, that has to be done by police. I don't ever mail it. That's just my practice. I don't want the other side to say they didn't get it. And I don't want to get it late to them. I want to meet that date that the court put on the paperwork. I have to give the documents to them by. Plus, if you're asking for a restraining order, there's been abusive conduct. So you probably don't want to delay serving the restraining order that protects you. So I typically do not mail the restraining order to the other side. Here is a sample of the proof of service form that we're saying needs to be completed and filed with the court. It's a DV-200. If it's a personal service, it's a different form if it's by mail, but again, I don't mail it. And if you see on this form, you'll see at the very top, you'll fill this information out. I fill out most of the caption. So I would fill out the name of the person asking for protection, which is you. I fill out the name of the person to be restrained, which is the other party. I fill out the case number, and then I would either leave blank so that the process server or the sheriff can do it, but they'll mark what documents got served in number 4. And then the person, they'll fill out the sections 5 and 6 where it says, I personally gave copies of these documents to person in number 2 on, and then it has when did they get personally served, what time, where, and then the server's information. So whether that's the police or the third party process server, it could be anybody over 18 to personally serve that is not you. But I use a process server because it's presumed to have been done when it's a process server. And again, if it's police, if it's a kick out order, it has to be police, so they'll fill this out. They'll actually use their own form, but the server's information will be in number 6. So the person who gave the document to the other side, that's their information. And then at the bottom, it's signed under declaration of penalty of perjury that this is true. And they'll put the date, they'll put their name, and they'll sign it. The next thing is using the evidence in court. Okay, so at this point, you've gathered everything together, you've filed it with the court, you've sent it off, and you've gotten it served on the other side. Now you have the hearing date. How do you use that evidence? So again, the judge will first ask you if you gave everything to the other side, or will confirm that you did because you've already submitted the proof of service. I would take extra copies with you in case you didn't, so that you can do it, but that might prompt a for sure continuance of the date, or the court might not consider it. So best practice is do not wait until the date of the hearing to give the court and the other side evidence, unless it's for, in my opinion, rebuttal, because at the hearing, the other side is saying something for the first time, and then you have something to prove that that's a lie, then that I would say is okay. But things that otherwise should be submitted in advance, you run the risk of the court not considering it, or a continuance of a new date. The judge might ask you questions about the evidence. So they might go through what you've submitted and ask you, what does this show? Who took this photo? What's in this video? Play the video. It'll go through it. It might have questions about what it is that you've submitted. You always want to explain what you've submitted, whether that's a photograph, a text message, a statement, a video, right? What you've submitted, how does that support the statements that you've made in your declaration to show that there was abusive conduct, or to show that there was a violation of the temporary restraining order, or even that shows that the other side is lying about something? Before I conclude, so the last slide is just a thank you. But before I conclude, I will say that you should try to gather your thoughts for this hearing. So I want to hone in on the hearing a little bit. So let me just go to the back slide. The hearing for a restraining order, for a domestic violence restraining order, once the temporary got granted and you get that first hearing date, you're at court with multiple other parties. It's usually a full calendar of maybe 10 plus other cases. It's what we call the 20 to 40-minute calendar. That's how much time the court has allotted to each case, either in the morning or the afternoon of a day. So you have a very short window. You might be there for a couple hours waiting for your case to be heard, but you in specific have a very short window of time to explain to the court what happened and why you need this restraining order to protect you. So I would, before your hearing, make sure that you've submitted everything in advance, so you don't have to worry about that anymore. You've submitted everything. You're not doing anything last minute. You've submitted your statement. You've submitted the declarations from other people, the videos, the text. It's all organized. You've done that all in advance. And if you can anticipate maybe some lies, I would bring whatever you think is part of the conversations or videos or photos. If there's anything that you think is a window of opportunity for the other side to lie about, and you have something to prove that they're lying about it, bring 3 copies of that with you to the court. I would bring an extra copy or 2 of what you've submitted to court in case anybody for any reason doesn't have it. And then collect your notes. Make notes for yourself. Don't always look down the whole time, right? Because this is your story. You've lived through this. So most of this should be information that you're able to just look eye to eye with the judge and explain everything to. But I would make maybe bullets of things that you want to hit, things like why you need it, if there's been any changes to the declaration, if there's been any additional incidents, or if there's been a violation. I would keep that as your frame, right? That's what the court needs to hear the most. And then if there's been abusive conduct, I would reference the court to the exhibit that shows that, right? So that the court can look through that. The date of the hearing, the other side might, so this goes over the evidence for somebody that's asking for the restraining order. But the person responding to the restraining order does not necessarily have to give you a response. They can just show up to the hearing. These hearings are set for such a short time frame that the court might need to specially move this to a different date to have both of you exchange any evidence. But they could be bringing the evidence for the first time to the hearing. They could be asking the court for a continuance, which on the responding side, they are entitled to. So just keep in mind that things could happen at the hearing that are unexpected. So just the best way to feel confident is to know the process, which I'm very grateful that the San Diego Volunteer Lawyer Program is putting on these videos on different aspects of the domestic violence restraining order process, because there is a calm of knowing what to expect and what the best practices are, so that you feel confident, and you go in there and put your best foot forward on what happened, why you need the protection, so that the court can consider that and determine whether or not a permanent restraining order for the first time up to 5 years should be granted in your favor. So lastly, I want to say thank you on behalf of myself, on behalf of the San Diego Volunteer Lawyer Program. Thank you for reading through all these slides and listening to me. If any of you need additional help or have other questions, please visit one of the legal clinics or the Family Law Facilitator's office, which are located inside the courthouse in San Diego County. Here is a list of them. You can also find their information online. If you Google San Diego Superior Court, you'll see these 3 different locations. One is central, and you'll go to the court where you're filing. And if you don't know where you're filing, you can go to the court's website at the San Diego Superior Court, and you can look for look in the family tab, look where it says where to file, and it'll tell you for filing domestic violence restraining orders, and it'll have a little chart with zip codes based on where you live. It'll dictate which court in San Diego County you'll be going to submit this stuff. And that'll be the same court that I suggest if you have questions or want more information. That's the court that I would go to. And here is the list. There's one in downtown. It's the central. There's one in Vista, which is the North County. There's one in El Cajon, which is the East County. And there's one in Chula Vista, which is the South County. Those are the 4 courthouses that comprise of the San Diego Family Court. And again, go to the court where you would file. And if you don't know, go to the court's website and it'll tell you on there where to file. So thank you all for your time. And again, if you have questions, feel free to please reach out to either the San Diego Volunteer Lawyer Program for their clinics or their staff's information, because staff is always available to help throughout the week, or the Family Law Facilitators. They're both located in these courthouses. Thank you and have a great day.